Hello and welcome to our webcast for September 27th, 2019. My name is Amy Hasbrook and I'm the director of Toujours Vivant, Not Dead Yet. TVNDY is a non-religious organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to the disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disabilities. We have a very full schedule. As of the Truchon decision, the trial in the Lamb case is postponed indefinitely, and plaintiffs suing Québec over nursing home conditions win class status. So, as promised a couple of weeks ago, we're going to bring you details of the Truchon decision. This week, we will try to explain the inexplicable by offering some more details on the Truchon-Gladu decision. In this decision, issued September 11th, the Quebec Superior Court ruled that the reasonably foreseeable death eligibility requirement in the federal medical assistance in dying law and the end-of-life criterion in Quebec's euthanasia statute violated sections 7, 15, and 1 of the Charter of Rights and Freedoms. Now, summarizing a 186-page, 770-paragraph decision in a few minutes won't be easy, but we will do our best. And please remember that we are not legal scholars. I went to law school. I worked as a lawyer in the US, but that was a long time ago, and I didn't sit for the bar here. So you should take our opinions with a generous helping of salt. Unlike in a jury trial, the Truchon case was heard and decided by a judge who wrote up her decision in two sections, her findings of facts and how she applied the facts to the different questions of law. So the first section is the findings of fact. In this part of the decision, the court weighs the different versions of the facts given by the plaintiffs and the defendants, then decides which version it believes. As a judge, her opinions and conclusions take on the weight of law. So that means that it's not just what facts she chooses, and it's not just her opinions. They count as law now. So that's why it's so important to know what they're deciding. The judge quotes at length from the doctor's descriptions of the plaintiffs, Mr. Truchon and Madame Gladu's physical limitations and deterioration. She portrays both plaintiffs as people who have lived well despite their disabilities, but who are now confronted with, quote, total dependence, unquote, and, quote, unable, quote, unquote, to live independently. In other words, the judge confuses the plaintiff's physical limitations with the effects of social policy. And that is a major problem that also occurred in the Carter decision. And it's a major flaw, I believe, in their reasoning. The court quotes medical professionals' consensus that the plaintiffs are not subject to external pressure based on the narrowest possible definition, and here comes Christian, yay, of that term. In the definition the court uses, the coercion or undue influence is exercised by one person against another. The court could have defined external pressure to mean any influence from external factors that affect the decision-making process, such as public policy that forced the plaintiffs into institutional care, but it didn't do so. And in choosing not to do so, it missed a very important opportunity. Other facts about the plaintiffs: they are not suicidal. They have symptoms of depression, sadness, and anxiety, but these are, quote, entirely consistent, unquote, with their situation. So basically, the court says because they're disabled, it makes sense that they would feel horrible.
Joining you later
is Christian Debray, who was out running errands, and I decided after 3:05 to get started anyway.
I was jammed by a truck.
Oh, those nasty trucks. And the court also said that the plaintiffs, both plaintiffs, are prisoners of their bodies. And this, all of the quotes are translations that I did from the original French decision. And yes, both applied to Monsieur Truchon and Madame Gladu. The court did use the word prisoners of their bodies. So that's what she thinks of disability.
Yeah.
The judge declared herself touched, quote unquote, by the, quote, dignity and modesty of Monsieur Truchon and the, quote, courage and determination, unquote, of Madame Gladu. We can't help but wonder if a court would use the same terms to describe disability rights activists who were advocating for their rights without ending their lives. So that was one thing we were thinking about. The court's examination of the legislative history of Bill C-14 is also an exercise in picking and choosing the pieces of the various reports that support the position the judge had already arrived at. She quotes from the final report of the external panel on options for a legislative response to Carter versus Canada that, quote, vulnerability in and of itself must not preclude the expression and recognition of an autonomous choice to pursue physician-assisted death, unquote. And yes, that really is in the report. However, she leaves out the part that says, quote, a request for physician-assisted death cannot be truly voluntary if the option of proper palliative care is not available to alleviate the person's suffering. And the court leaves out the bit about enhancements to home care could help alleviate some sources of vulnerability and suffering, potentially reducing some individuals' desire to seek physician-assisted dying.
Yes, she just skipped it a little bit.
Yeah, and those weren't the parts that she thought were important. So she just didn't mention those.
We was never important.
Right. The judge begins her description of how medical assistance in dying works in practice by saying that the only people who can understand it are doctors who practice euthanasia.
Who practice euthanasia? The one who doesn't
Right.
are not.
They can't understand.
No.
And doctor knows best, as we all know, is standard from the medical model. So there we are. We're back into the medical model. She dismisses as theoretical and administrative the opinions of all other witnesses who have studied assisted suicide and euthanasia. And we'll get to more on that in a few minutes. The court rejects the possibility that anyone could be euthanized who did not have a long history with the medical establishment.
It never happened.
Couldn't happen.
No, it never happened.
Couldn't happen.
But it happened a few times.
Right.
And we just have proof of that.
Right.
But it doesn't want to look at it.
Right. The judge talks about the requirement that the second doctor be independent of the first. She talks about his great safeguard, right, wrong, neglecting to mention that Québec eliminated that requirement by order of the health minister, not even by a legislative act.
So it
by
doesn't
order
exist.
Of the health minister.
And even when it was existing, the second doctor was only consultative.
Right, and that's still the case. And that was done in 2017 because there were too many cases of non-compliance with the safeguard.
Already.
So they had over, I think, 29 cases of doctors who were not independent. And they said, oh, well, this is too many. I guess we'll have to just eliminate the requirement.
Yeah.
Because it's
So
not working.
less protection.
Yeah. In its description of the quote unquote crucial meeting with the person making the request, alone or with their family,
Oops.
the court says nothing about raising the possibility of additional treatments, palliative care, suicide prevention, non-institutional care, or any other alternatives to death.
Yeah, death is the first choice or whatever.
Death is the be-all and end-all.
Yeah.
The court does not talk about doctors engaging in a decision-making process. The judge seems to take the approach, is there any reason not to provide euthanasia? That seems her approach.
Yes.
So her description of the administration of euthanasia, of the euthanasia process, is idealized. There is no discussion of last-minute jitters, adverse reactions to the drugs, just delays or other complications, nor is assisted suicide even mentioned.
Don't look at it so it doesn't exist.
Right. Granted, there are only a few people who've chosen assisted suicide as opposed to euthanasia, but, you know, that doesn't mean it isn't a possibility, but the judge just doesn't even mention it because apparently it doesn't exist.
Yeah.
The court accepts the testimony of Dr. Nogue that doctors spend 2 to 3 hours on paperwork after the procedure, but the court doesn't mention the errors or the late and missing reports documented by Quebec's Commission on End-of-Life Care.
Official Commission of Quebec.
Yes, this is Quebec's government body that's supposed to oversee.
And it is favorable to assisted suicide and euthanasia.
Right, and they've documented these problems, but the judge didn't feel that that was worth mentioning.
Doesn't worth mentioning because if you mention it, it exists and it should not exist.
Right. Yeah, no, she's just going to take the word of Dr. Nogue, who says that they spend 2 or 3 hours of paperwork.
Yeah, Dr. No is a known death doctor.
Right. He's promoted euthanasia and assisted suicide. Well, euthanasia in Quebec.
Yeah.
Finally, the court simply ignores the 4% non-compliance rate described in Quebec's Commission on End-of-Life Care in its April 2019 summary report. And
the official report, again.
Right, and you remember we talked about what a 4% failure rate would mean with airlines. Who would get on?
Take a plane if
Right.
you have only 96% of
Yes.
chance to get to your destination.
Yeah.
Not sure.
Right. And the report also documented 11 euthanasia of ineligible people, 55 violations of safeguards,
Only.
and 134 cases that had not been reviewed a year later.
Only.
Yeah.
Always only.
Yeah. Oh my gosh. Okay, so the court says that the question of who is a vulnerable person, quote unquote, comes down to the individual evaluation of capacity, and that doctors know how to assess capacity because doctor knows best. The court responds to the issues raised by Dr. Scott. He's a doctor, but he's not our doctor.
No, it's not our doctor.
By Dr. Scott Kim.
He's just international known specialist.
Yeah.
Just only
internationally known expert. As to the problems with capacity assessments by discrediting him, saying that Dr. Kim's evidence is, quote, insufficient or theoretical, unquote, and that he is unfamiliar with assisted suicide and euthanasia in Canada.
In Canada. Oh, in Canada.
Oh.
Okay, because it's very different from Belgium or Netherlands.
Right.
Okay. But we copy a lot from Belgium.
Yeah.
And Belgium have right now, and in the Netherlands, they have a lot of complaint right now. a lot.
There are some, anyway. The court summarizes its finding of facts, and I was thinking this is sort of the tragic comic section of our report. And we're kind of making light of this, but this has actually been extremely difficult for me to do this. It's been a very hard couple of weeks going through this whole decision, not just because it's hard work, but because it's so upsetting and sad.
It attacked you personally.
Yes, it's very personal. Okay, summarize its finding of facts. 1, medical assistance in dying as practiced in Canada is a strict and rigorous process that, in and of itself, does not has no obvious weakness. Oh my gosh. Okay. Yeah. Sent to and detect ambivalence, mental disorders, and affect the decision-making process or cases of coercion or abuse.
If I was a psychiatrist, I will fight on it right now because doctor will take our place.
Right, exactly. Basically, she's saying doctors know how
better than psychiatrists.
Yeah. And no, I don't.
Not good.
And of course, they don't take into consideration the social factors, but those don't matter.
And you have to know that is any doctor, podiatrist or whatever doctor,
if the doctor receives the request, then they are qualified to assess
the
capacity.
Any doctor are better than psychiatrists. Any doctor. For do psychiatric thing. Yeah.
The vulnerability of a person seeking medical assistance in dying must be assessed individually according to their particular characteristics and not according to a reference group of vulnerable persons. Because we don't want any social issues.
And we don't want any standard, whatever it is.
The physicians involved can distinguish a suicidal person from he says patient. This is always patient. I always substitute person because
patient is a kind of...
Patient is a medical term and people
always
are people.
And when you talk of life and death, it's
people.
Greatly personal, and people is better.
Physicians involved can distinguish a suicidal person from a person seeking medical assistance in dying or patient.
Not always true.
Well, that's because she doesn't believe that suicide is medical assistance and dying is suicide. There are important differences between suicide and physician-assisted dying, both in the traits of the people making the request and the reasons that motivate them.
Not true.
But she trots out the suicide prevention groups that say there's a difference, and so then they must be doctors who practice in Canada, so they must know. Neither the data in Canada nor Quebec nor the foreign data show any drift, slippage, or even increased risk for vulnerable people when the imminent end of life is not a criterion for eligibility for medical aid in dying.
Completely false.
Excuse me. Oh,
Sorry, I have a bad case of cough.
Shut up, my gosh. You have a cat in your throat.
Where is the cat?
Today. Cat video.
No cat video today? Okay.
The cat's in your throat. Okay, so those are her conclusions of fact. Now she's going to apply these facts to the law.
Okay, if the facts are wrong.
And what happens when you apply those facts to the law? The court starts with the question of whether the Carter decision creates a constitutional right to medical assistance in dying Except that it's not really the question the judge answers.
Yeah, and death is not the right.
Right.
Okay,
Death
because
is a fact.
you
It
can
happens to
suspend a
everybody.
right. You could not suspend death.
Right.
Okay.
The judge ends up talking about whether the reasonably foreseeable death eligibility criteria is supported by other legal decisions. So that's not the same issue. And it's a little weird that she says she's going to answer one thing, but then says something else.
Yeah.
The court says the Carter decision didn't limit access to medical assistance in dying to people at the end of life, but it was meant to enable people to avoid a life of suffering.
No.
Well, I mean, that's one interpretation.
It's an interpretation, but a very, very wide interpretation.
Next, the court looks at whether the reasonably foreseeable death requirement violates plaintiffs' rights under Section 7 of the Charter of the Rights. Under the Charter of Rights, the right to life, liberty, and security of the person. So the judge reminds us that the Carter court said that prohibiting assisted suicide infringed the plaintiff's rights to life in that it forced them to commit suicide while they were still able to, which might be earlier than they would otherwise want to die. The Truchon court decided that the reasonably foreseeable death requirement had the same effect on people with disabilities by making them ineligible for medical assistance in dying. That is her logic. And again, it doesn't take into account social policy, suicide prevention, anything like that.
Yeah.
The court agrees with the plaintiff's view that their liberty and security interests are also violated because the reasonably foreseeable death requirement impinges on their freedom of choice and the exercise of their autonomy. Well, what about the policy that prevents them from living independently? Doesn't that impinge? Oh,
no, don't look at it.
Yeah,
it does not exist when you don't look at it.
Don't look behind the curtain. Yeah. And one thing that the court talks about a lot is how people are forced to continue to live. And I'll get to that in a minute. As stated in Section 7, people cannot be deprived of these rights except in accordance with the principles of fundamental justice. That's what it says in the law. And so restrictions cannot be arbitrary, overly broad, or disproportionate to the purpose that they're meant to deal with. In other words, if the limitation of rights exists for a good reason, if it does what it's supposed to do and has the minimum possible impact, then it's okay. So then she has to apply the test to the case at hand. In this case, the court finds that the reasonably foreseeable death requirement goes so far beyond the objective of protecting vulnerable people that it has no, quote, real connection to the objective, unquote. The court says that the reasonably foreseeable death requirement is disproportionate in that it forces plaintiffs, quote, to continue their existence in suffering that is as intolerable as it is useless. And this requirement, therefore, creates a real obligation to live imposed by the state. We often talk about the fact that people have a choice of if they want to commit suicide, but what we also say is that we don't want people to be committing suicide. No. And we have a public policy against people committing suicide.
That's true.
That's why we want everybody to have equal access to suicide prevention.
Great. That's the truth.
And the supports they need to continue living. And this is
the right of people are supposed to be equal.
Right. And that's why
what she said, but misinterpreted.
That's where we feel like this decision just tombalo, falls in the water.
Yeah.
The judge then looks at Section 1 of the Charter to see if it limits plaintiff's Section 7 rights. Section 1 says charter rights are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So the test to be applied is similar to the principles of fundamental justice, and it's almost identical, actually. And the court reaches the same conclusion. The court accepts that the Attorney General has met his burden of proving that the goal of protecting vulnerable people might be a pressing and substantial goal.
So it's a right goal, and he proved it.
Yeah.
Okay, nice.
It's a pressing and substantial goal. At this point, this is a little aside here. You might be wondering, what about the goals of affirming the value of the lives of disabled people and suicides? Because those are for limiting access to people who were at the end of life.
Yeah. And even in the Carter case.
Yeah. Well, that hadn't really come up yet, but anyway. Well, the court disposed of those in its discussion of principles of fundamental justice by saying that they were broad statements of societal values rather than legislative goals, so they don't count.
So it's a goal of the society, but don't look at it, it doesn't exist.
Right.
Same principle. It exists, but don't look at it, it will not exist.
Right. The second part of the Section 1 test asks if the means were proportional to the objective. First, there must be a rational connection between the reasonably foreseeable death criterion and protecting vulnerable people, which the court did allow. But the court found that because it went beyond a minimal impairment of plaintiff's rights, the reasonably foreseeable death criterion failed the Section 1 test. Therefore, it violated their rights. Okay, so now the court looks at Section 15 of the Charter, which guarantees equality rights by saying that everyone is equal under the law. But Section 15 adds that the government can create laws, programs, or activities with the goal of improving the situation of a disadvantaged group. Cool.
Yeah.
Yeah. At paragraph 655, the court rejects the Attorney General's position that the reasonably foreseeable death requirement doesn't create a distinction. So the government says this applies equally to everybody. It doesn't only apply to disabled people, it applies to non-disabled people, to people, as long as you're at the end of life, you are eligible, but if you're not at the end of life, you're not eligible. Court disagrees. It disagrees because it disagrees with the government's position, but it doesn't really explain why. Which is kind of funny in a long decision like that. It just sort of
when's a matter of
skips over it. You know?
Yeah, just skip some small things.
We disagree.
Yeah.
Next point. The court further states that the reasonably foreseeable death criterion, quote, does not take into account the specific situation, characteristics, and actual needs of applicants in a way that respects their value as human beings. And, quote, perpetuates prejudice and disadvantage for people with physical disabilities, unquote, because it assumes plaintiffs are incapable of making decisions about their lives. That's what the court believes. Once again, we think the court confuses a lack of choice with an inability to make a choice.
Yeah.
And that is a really, really important point that happened in the Carter decision, and they missed it, And this court missed it. And if they keep missing this point, they really
the society will suck very soon.
Yeah. The judge ruled that the Section 15 violation was not saved by Section 1's provisions by a process similar to that used in the Section 7 analysis. The court suspended the effect of its judgment for 6 months to allow Parliament and Quebec's National Assembly to bring the laws into compliance. The judge said that changing the law shouldn't take long because all the possible legislative options were weighed when Bill C-14 was adopted. Not. The court didn't mention the substantial delay caused by the federal election.
Oh, it leaves us at least 2 months.
Yeah. The court also allowed the plaintiffs an exemption from the suspension, meaning that they don't have to wait to be euthanized. And the Attorney General has until October 11th to appeal this decision, which would be a great birthday present from Christian, because his birthday is October 11th. So if they decide to do that, that would be good. Analysis. The next topic is the trial in the Lamb case is postponed indefinitely. The British Columbia Civil Liberties Association has announced that the trial in the Lamb case, which was scheduled to take place in November, has been adjourned. The constitutional challenge was filed in 2016, and this was also a challenge to the reasonably foreseeable death criterion. The move comes 6 months after Dr. Madeline Lee, a cancer psychiatrist who oversees medical assistance in dying at a network of Toronto healthcare facilities, submitted testimony on behalf of the federal government, stating that Julia Lamb's death could be considered reasonably foreseeable. Dr. Lee cited the AB case in which an Ontario Superior Court ruled that a reasonably foreseeable death does not have to be imminent or predicted within a specific time frame. That case came out in 2017, and we covered it, and there's a link in our text. You can go look at it. According to the Globe and Mail, guidelines published by the Canadian Association for Medical Assistance in Dying Assessors and Providers also, quote, encouraged doctors and nurse practitioners to read the vague term broadly with no specific measure of how long a patient has left to live, unquote. Shortly after the adjournment was granted, the Quebec Superior Court ruled that the requirement for the person's natural death had become reasonably foreseeable was unconstitutional and should be removed. The timing of this was really quite impressive. We heard that they were dismissing it on the 10th, and then the Quebec decision came out on the 11th, and we sort of scratched our heads. We certainly did. Upon hearing the news, Ms. Lamb said that the shadow which hung over her and her fears of future pain and suffering had been
fears lifted. Of future pain. Remember it.
She wasn't in pain. She was afraid she would lose her autonomy. She was afraid she would be in pain. No. Although she has no immediate plans to die, she is relieved to know that she now has the option. She had the option before.
Yeah.
Okay, Ms. Lamb's condition has reportedly worsened since the claim was filed, yet she has also gotten married, traveled, and volunteered while being surrounded by supportive family and friends, unquote.
So why?
We are saddened by the inconsistency of Canadian society, which has allowed Ms. Lamb to thrive while presenting death as a reasonable response to discrimination, struggle, and fear.
Just because she feared, okay?
Yeah.
That's unbelievable.
Yeah.
Normally, fear should not be considered. whatever happened.
Right. Okay, our final topic. Plaintiffs suing Quebec over nursing home conditions win class status. Yay! A year ago, we discussed a class action lawsuit filed against Quebec health authorities over conditions in nursing homes, or as we call them in Quebec, CHSLD, Centre d'hébergement de soins de longue durée. The named plaintiff, Daniel Pilote, is in his late 50s and has lived in long-term care for about 5 years because he doesn't qualify for home-based assistance. Oh,
a society thing.
A public policy thing.
Don't look at it.
Yeah, it doesn't exist. That's not an external pressure.
No.
The lawsuit claims that conditions at the facilities violate residents' rights under the law and the charter. Some of the problems include providing only one bath to residents per week, maximum, because we've heard of situations where people can't even get that.
Yeah.
Or they get a sponge bath. Excessive use of physical restraints and using antipsychotic drugs to sedate residents. Not helping residents to use the toilet and forcing them to wear diapers. Not taking enough time to help people eat so that they nourished.
Don't long-term facility are all thin.
Yeah. And waking residents in the middle of the night to perform personal care tasks. Wake up, it's time for your bath at 2:00 in the morning.
Yeah.
Yes, indeed. Before the suit could progress, the Quebec Superior Court had to decide whether the residents' problems were similar enough, given their individual needs and the differences in policy and practice in the various institutions, for a small group to represent a whole class of residents whose complaints could be addressed. Together, now that the decision has been made, the lawsuit can continue. The text of the decision is available online in French, and we have a link. The story was barely noticed by the media, except, of course, the Truchon case got all kinds of coverage.
Yeah.
It occurred to us that when presented with a disabled person who wants to die, Canadian society will bend over backwards to grant their wish, and the media will shout it from the rooftops. But when disabled people fight to improve the conditions under which they live, nobody seems to care.
One thing that bugged me really much is in this decision, the court says there is things who are affecting our choice. And the judge say, no, that thing doesn't exist.
Right.
At the same time,
right.
To court.
Right. Yeah. Okay, so this was pretty sad. If you want more information about the topics that we discuss here, you can visit our Facebook page at facebook.com/toujours vivant, not dead yet. You can also visit our website at tvndy.ca, and we have all of our webcasts online, and we have a list of the topics that we covered, and it's just great. You can email us at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christian for
Thank you, Amy.
And thanks to you for being there. We will see you soon. Bye.
Bye.